Should we make a start? Excellent. Well, hello and welcome to the final webinar in this three-part series that deals with the most common warning signs that arise in construction projects. Today we're looking at ineffective project management and whether this is fueling tension in your project. This, of course, follows on from the first two webinars in this series, design defects on site and also the construction program. These three topics were all voted the most common sources of woe on construction and engineering projects by the readers of our recent report, Spotting the Risks in Construction and Engineering Projects. Now, before we get into the substance of today's talk, let's make some introductions. My name is James Clark. I'm a partner in BCLP's Specialist Contentious Construction and International Arbitration Practice here in Singapore.
My name is Sara Paradisi, and I'm a senior associate in the construction disputes team, and I'm also based here in Singapore. So just three quick housekeeping points before we kick off. Firstly, you'll see a toolbar on your screen. You can use this to ask us private questions on any of the issues raised today, which we encourage. We'll get back to you as soon as possible. Secondly, there's also a handouts area where you can download our recent report, Spotting the Risks in Construction Engineering Projects. Some of you may have already seen the report, which examines 10 of the most common early warning signs on construction projects. And finally, you can find recordings of all three of these webinars on our website, on our YouTube channel. So let's get started. Today we are going to talk to you about how to detect and treat the symptoms and underlying causes of ineffective project management. Specifically, we're going to be looking at the evolving role of the project manager in the construction and engineering industry over the course of the past 20 years. We're then going to look at the competing duties of the project manager in his or her role, on the one hand as the employer's agent, and on the other hand as the impartial arbiter of contractor's claims. We're then going to look at the early warning signs, so some of the signals from site that should really prompt closer attention on how the project manager is approaching his or her role. What recourses are available for ineffective project management, and we're going to look at this both from the perspective of the employer and that of the contractor. And lastly, we are going to give you some suggestions on what all parties can do to contribute to good contract administration. So before we move on, we just want to make a small point on terminology. Today we're discussing the role of project managers. However, of course, this is just one given name to the role that we are in fact discussing. Depending on the form of contract that you're working to, this role might also be designated as contract administrator, architect, engineer, supervising officer, or employer's representative. For the purposes of today's talk, we'll simply use the term project manager. I'm just going to hand over to James.
Well, first things first then, let's discuss the evolving role of the project manager. And perhaps why do we say evolving? Well, over the course of the past 20 years or so, the construction and engineering industry has seen a move away from what we might call conventional forms of contracting, and there's been a very strong trend towards what we now call collaborative contracting. Now, the purpose of this webinar is not really to dissect what that means in practice or even to comment on the efficacy of collaborative contracting, whether it delivers better results on your projects. But what is true is that this trend has augmented the interfaces between the various players on a project. Those interfaces need to be managed, they need to be coordinated. Added to that, projects have undoubtedly grown in scale and complexity, and also different procurement and pricing methods seek to allocate risk, responsibility and reward across more of the parties involved in the design, management and execution of the works. All of this inevitably results in the need for greater overall management and coordination of all of those efforts. So it seems to us that the role of the project manager has grown both in the scope but also in the importance in the delivery of modern-day construction and engineering projects. It is perhaps reflected very bluntly through the way in which the role of the project manager has now been documented so extensively in many of the modern day forms of standard forms of contract. And we're going to take FIDIC, the NEC, JCT in the UK, and the PSSCOC in Singapore as some examples.
So looking at the competing duties of the project manager, the best way to approach this and to give you some context is to show you the contractual structure of the traditional lump sum procurement method. The employer will enter into the building contract with the main contractor, who in turn engages the subcontractors to carry out some or all of the work. The employer also appoints the professional team, which will include the architect, the structural engineer, the M&E engineer, the quantity surveyor, and the project manager. Therefore, it is the employer that enters into professional appointments with the professional team. What this means is that there is no contractual relationship between the contractor and the project manager. However, the project manager finds itself in a situation of being tasked with carrying out contract administrative functions in relation to the building contract, which puts the project manager in an invidious position since he or she is performing two different types of functions under the building contract. First, in many matters, he or she is performing as an agent of the employer and is bound to act on his or her client's instructions, whether or not he agrees with them. And secondly, in relation to many other matters, such as, for example, when dealing with contractor claims, project managers are asked to use their professional skills to form their own opinion. And this is on the basis that the employer and the contractor make their contract on the understanding that in all matters where project managers have to apply their professional skill, they will act in a fair and unbiased manner in applying the terms of the contract. Of course, the precise role and duties of the project manager will be determined by the terms of the contract under which they're required to act. For example, the NEC suite of contracts is well known for being onerous in terms of the administrative responsibilities placed on the project manager. The role of project managers, or engineers as they're called, is also central to FIDIC, and the PSSCOC, developed by the Building and Construction Authority of Singapore, provides for the role of the superintending officer, or the SO, who is appointed by the employer to administer the contract. So just looking at some of the onerous responsibilities which are placed on the project manager under NEC 3, these include monitoring progress and managing time, approving programs, issuing project manager instructions, reviewing and accepting the design, accepting subcontractors, assessing compensation events, issuing early warnings, maintaining the risk register, and assessing amounts due for payments. Naturally, you will see very similar responsibilities in each of these areas that I've just described in relation to NEC in FIDIC. So if we look, for example, the 2017 version of the FIDIC Yellow Book, just to highlight one example, under clause 8.3, the engineer is required to review and notify the contractor if its program does not comply with the contract or reflect actual progress that has been made. Importantly, which is one thing that I wanted to highlight, is if the engineer does not issue a notice to the contractor within 21 days that the contractor's program either does not comply with the contract or reflect actual progress, the engineer is deemed to have made no objection. Under the PSSCOC, in addition to responsibilities for management of the program of the work, dealing with issues related to costs and variation, one feature of the SO's role which is worth highlighting is that under clause 32.2, the SO has to issue a payment certificate showing the amount that the contractor is entitled to within 14 days of receiving a payment claim from the contractor. This is a very important provision because in Singapore, where you have a security payment regime, this means that the employer is only allowed to raise defenses in adjudication based on the reasons provided in the payment certificate issued. So that was just a brief overview of the role of project managers. James is now going to look at some of the typical complaints that are made against them.
Thanks, Sarah. At the end of a dispute where we've been representing clients, we typically conduct a lessons learned session, either be it the employer client or the contractor client. And the purpose of this is not only to see how the dispute has panned out and how things have gone, but also to reflect on how the client and the parties found themselves in dispute in the first place. It's from those sessions that we've identified over time what we feel are the most common complaints that are made about the performance of a project manager, and these are listed in this slide here. Now, I would like to have a bit of fun. I'd like to open this up to our audience and maybe run a short poll with you just to see what you feel are the most common complaints made against project managers. So, by clicking on the options that should be appearing on your screen right now, is it a failure to coordinate with the contractor and the members of the design team? Is it the poor management of the program and failure to report progress and delay accurately along the way? Alternatively, is it the fact that the project manager does not operate the contractual mechanisms for the assessment or for the proper assessment of the contractor's claims for time and additional money? Alternatively, is it simply the fact that the project manager does not effectively communicate between the employer and the contractor? Or finally, could it be an inadequate connection with the quantity surveying team, meaning that the employer feels that there's poor verification of the project cost control? Now, I'm going to leave it over to you for 5-10 seconds. Please vote, and let's just have a look, see what we think the most common source of complaints might be. What have we got? Quite even Stevens, in fact. So there's a fair spread here across failure to coordinate with the contractor and the design team, poor management, assessment of claims, and ineffective communication. Very interestingly, it's nothing voted in relation to the inadequate verification of project cost control. Now, I'm not sure if that's maybe viewed more in the realm of the quantity surveying team. But slightly ahead of everybody else is the assessment of the contractor's claims for time and or money. And I think if I had to put any money on that myself, that probably would have been the one. Mostly probably because it is in that execution of that quasi-judicious role that Sarah was referring to earlier on, that the parties look to the project manager to do a proper job of assessing entitlements so that they don't need to go off to adjudication, DAB, arbitration, or litigation to have the arguments themselves. Well, moving on. We've just had a look at particular examples of performance issues of the project manager and of the services that the project manager is responsible for themselves. And what I want to talk about, though, is in the real world, it's really, projects aren't hindered or stressed by problems of one party alone. And it seems to us that given the central role that the project manager plays in amidst all the other parties involved in a project, they are very often pictured as the fall guy. They are the ones that attract blame for the poor performance of all aspects of the project because they are in that point of coordination. And it may well be that they are blamed for matters that, strictly speaking, aren't really their problem at all. It's just they are at the centre of it. So whilst we can focus on the quality of the performance of the project manager's responsibilities, it seems to us that tensions are more frequently fuelled by how a project manager deals with or manages the underlying strains in the construction, the relationships created by a construction contract. And in our experience, and given the nature of that role, it seems to us that it's the nature of the personalities and relationships that the project manager establishes that will really influence the propensity for issues to result in dispute. Now, to illustrate this point, just for the purposes of today, we've taken two extremes of those types of personality that we've encountered and which we see fueling or antagonizing disputes that might otherwise occur. On the one hand, you've got what we might call, or what we've called at least, the stubborn defender of the employer's rights. These project managers might zealously defend the contractor's claims, irrespective of their merits, and are completely committed to maintaining the employer's expectations to deliver the project within the original price and duration, no matter what. At least that's what they might report. These types of project managers attract complaints by the contractor that they are in the employer's pocket and lack the fairness and impartiality that they're required for. On the other hand, you've got what we've called the pushover, or the follower of the path of least resistance. Now, these might be the project managers that like to say yes, or rather are afraid to say no. They seek to avoid disputes with the contractor pretty much at all costs. They are then seen as a pushover by the contractor and tend to result in the employer becoming extremely alarmed towards the end of the project, as suddenly they realise that the value of the works have ballooned over and above all expectations set out in the original budget. Now, of course, for the purposes of today, we've just given you two extremes, and naturally, project managers and the way in which they perform their role will almost always fall between the two of those two extremes. But we're going to have a quick look at how that might actually feature in practice.
So for the purposes of illustrating the various problems that James has just outlined, we thought we would look at a typical scenario which may arise on some of your projects. And as a result of that scenario, the warning signs which could have arisen on site, which would prompt closer attention. Some of you may remember the fictional case of the power tower from our two previous webinars. So the power tower is a 4 gigawatt coal and biomass-fired power plant in the Middle East. The issue that has arisen relates to a clash in the specifications contained in the main construction contract. Because of the clash in the specifications, the contractor has issued multiple requests for information, or RFIs, which have gone unanswered by the employer or its design team. The contractor is claiming that the clash in specification requires the employer to issue a change or variation order, and in turn, the contractor is claiming that the change or variation order will also require a change in materials, which will delay procurement. And of course, as a result of all this, the contractor is claiming additional time and money.
Well, how might a stubborn defender approach all of these? Again, taking the extreme, irrespective of the allocation of design risk and the nature of the discrepancy in the standards or specifications, a stubborn defender project manager might just simply dismiss the contractor's claim on the basis that all of this falls within the contractor's scope of design responsibility. And in fact, there just is no conflict. It's for the contractor to resolve. That would lead to the natural conclusion that the RFIs are all misplaced, they're irrelevant, and they're simply not for the employer's team to respond to. In turn, the legal basis on which a change or variation has been asserted would simply be denied and dismissed. In relation to procurement, and late procurement in particular, the project manager might seek to place blame on the delays to procurement to the contractor's own relationship with its supply chain. Where the alternative materials brought about by the change cost more because they attract different rates, the project manager might look to argue that all of that is included in the lump sum price, or alternatively that rates included in the bills of quantities in the contract don't warrant to be adjusted because they simply represent the value of the materials originally in the contractor's scope. All of this is going to culminate in the blanket rejection of delay and cost claims advanced by the contractor in consequence of these sort of scenarios. Now, taking a step back from the detail of the hypothetical there, what might a construction account, look like that is labouring under the influence of a stubborn defender? Well, what we see and over the course of disputes is you might see some certified by the project manager in a very static fashion. So nil valuations of interim applications by the contractor, resulting in a polarisation of positions with the applications rising gradually with the value of the works, and yet the project manager simply maintaining the original contract value. And this is often fueled by a disputed variation account, a lack of recognition by the project manager that any changes actually occurred on the project. You might also see an increase in the amount of delay notices asserted by the contractor, and you might see increasingly terse responses to those delay notices, and they might be roundly dismissed by the project manager simply because of being out of time, non-compliant, the basis of the risk event being denied, or alternatively, a failure by the contractor simply for showing cause and effect or any practical impact on their program. Any effort by the contractor to mitigate those delays will, of course, then prompt a bunch of correspondence about whether or not that is indeed mitigation of the contractor's own delay, or alternatively, whether it's accelerative measures required by the fact that the contractor has been delayed by events for which the employer is responsible. All of these factors will inevitably result in increasingly emotive and contractual correspondence arising towards the end of the project. Completion will become a struggle as the employer or the project manager seeks to make sure that every single aspect of the works is compliant. And then ultimately, you'll see the combination of that correspondence brewing into a dispute. So, what would the warning signs look like if the project manager is a follower of the path of least resistance or pushover, to use our earlier terminology? Well, the first thing you will see is that the project manager will appear disengaged from project correspondence relating to the issue of the RFIs or any meetings set up to discuss this issue. He's unlikely to have a firm opinion on the RFIs and will just forward relevant correspondence to the parties. Despite not having expressed an opinion on the RFIs, the project manager will accept the contractor's application for a change without challenge. He will also accept without challenge the contractor's request for a change in materials without checking if the materials, with the cost of those materials, or it falls within the lump sum contract price or the bill of quantities. And lastly, he will accept the contractor's claim for additional time and cost without challenge. And so, taking a step back from the specific facts, the warning signs that everybody should be looking out for in a situation such as these are, as I've mentioned, the project manager giving the impression of acting as a postbox between the contractor and the design team, and appearing disengaged from project correspondence and in meetings. In turn, variation and delay-related claims are accepted without challenge, or on account assessment are made to defer proper scrutiny for another day. Another thing that you will see is certified applications for payment in the early stages of the works may appear front-loaded relative to the reported progress of the works. What this means is that in time, final account negotiations fueled by inflated contractor claims become hard for the employer to navigate with little room for movement against an overly generous starting point. In all this, of course, the contractual mechanisms will not have been followed. So the contractor will not have been held to account for example, lack of notices in respect to variations or delay, or the project manager will have failed to issue notices asserting competing positions for a fear of prompting a dispute. Project progress reports may lack detail or frequency, which will prevent the employer from defending the contractor's claims further down the line.
And another thing which we will often see is that the project manager may be pressured into certifying early completion of the works, despite outstanding, incomplete, or defective works. Or alternatively, the project manager may be pressured to resist calls to assert the contractor's liability for delay and enforce the employer's entitlement to liquidated damages. Of course, we're not suggesting that behaviors at either end of the extremes are necessarily causes of disputes in their own right. However, in our experience, they do fuel underlying claims or sources of dispute and severely impede early resolution of disputes before the parties are led to engage formal dispute resolution mechanisms.
So what recourse is there to the parties for ineffective project management? Well, I'd like to take this slide into two parts, if I could. The first is just to comment briefly on what happens under the construction contract if the elaborate provisions for the management of it are not administered. And then secondly, what actually can the employer or the contractor do vis-a-vis the project manager if they are not performing well? Take the first matter first. That is actually a relatively simple answer in the sense that you have to look at the terms of the contract to see whether or not it caters for a failure by the project manager or indeed any other party from operating the mechanisms set out in the contract. Now, Sarah gave you some examples earlier on in relation to some of these forms of contracts where you have elaborate contract administration mechanisms. And she gave an example of the first type that you see, which is in the FIDIC 2017 suite, where in relation to the program, there was a deeming provision if the project manager didn't respond to the proposed program, saying that the project manager had no objection. There's a similar provision, a similar deeming provision in relation to contractors' claims. So where a contractor makes a claim under the FIDIC form and the project manager fails to issue a determination either correctly or in time, then there is a deemed rejection of that claim, and that forces the contractor to give a notice of dissatisfaction in order for that claim then to proceed to the next level. Now, other contracts do not provide those fallback provisions and simply expect that the parties will administer those terms as they are intended. And it's here that we exercise caution, or at least we advise that you exercise caution in spotting when that's happening. And too typically do we see disputes arising out of the parties just drifting on and then abandoning the mechanisms under the contract. In our view, it's better to have engagement with both parties to flush out the issues that are arising at the time. If decisions are not being made, if applications are not being responded to, you have those dealt with there and then. And again, Sarah referred to the security of payment regime that we have in Singapore here, but also in the UK and throughout other jurisdictions. You have mechanisms that are brought in by law that really do force these matters to come to a head at some point. Now, in relation to what you can do with a poor-performing project manager, well, if you're the contractor, there's a fundamental issue here. And again, Sarah referred to this before. There is no direct contractual relationship between the project manager and the contractor. The contractor's relationship and the contractor's contract is with the employer. The project manager acts as the employer's agent in the discharge of the employer's duties and functions under the contract. And so, therefore, it's important to make sure as the contractor that the employer truly is engaged with what the project manager is doing on their behalf, because ultimately the contractor's claim is against the employer. Now, if you're the employer, of course, you do have a direct contractual relationship with your project manager, and that is in the terms of appointment, the professional appointment. And the nature of the obligations of the project manager are key, because if you look again and have a think again about where the project manager sits in all of this and the role that they have vis-a-vis with all the other players involved, it is an obligation of professional services. And what that means is the project manager is obliged to exercise reasonable skill and care. What that means is that the claim that the employer would have to bring would be to demonstrate a breach of that reasonable skill and care in order to establish liability. And that means effectively showing negligent performance by the project manager of its obligations. Added to that, again, given the risk profile on these projects, Typically, project managers' terms of appointment will include extensive limitations of liability in the situation of poor performance by various other parties, or just generally. And in reality, it's argued that it's very rare that an employer will actually find any effective recourse or meaningful recourse against the project manager in light of those limitations of liability. All in all, the message here is it is a difficult claim to bring against a project manager.
Which leads us to the key message that we want to leave you with, and it's our mantra, and it's actually been the theme of our recent report, Spotting the Risks in Construction Engineering Projects, which is prevention is better than cure. So when it comes to effective project management, active engagement by both the employer and the contractor is key. All parties should take an active and collaborative approach to the administration of the contract. From the perspective of the employer, as with all professional appointments, the success of the appointment ultimately boils down to the quality of the individuals engaged. Therefore, the employer should ensure that it selects the project manager carefully. Importantly, the employer must ensure that the project manager is both empowered and tested in its role. And what do I mean by that? The project manager must be permitted and encouraged to exercise impartiality and good judgment. But experienced employers will not rely solely on the good performance of its project manager. Employers should actively engage in the project manager's management of the project, but at the same time, bench test its procedures and even instruct peer review of its assessments. In our experience, sophisticated employers often set up their own team mirroring what the project management team is doing. And this is not just to police the project manager, but also to support the project manager and foster collaboration. For example, the two teams should conduct joint site inspections, joint review of updates, and this will naturally lead to an increased dialogue on the contractor's entitlements and will avoid any late surprises at the end of the project. From the contractor's viewpoint, a collaborative approach to the administration of the contract and issues that arise is likely to result in a more constructive relationship with the project manager. However, the contractor should also bolster its own administration of the contract and demonstrate underlying merits and credibility in its position to avoid the polarization of the parties' positions on the final account. This is achieved through consistent and thorough record keeping and reporting, coupled with an open approach to the assessment of its account. Again, so that there are no late surprises at the end of the project.
So to sum up, the title of this talk was Ineffective Project Management, and you may be forgiven thinking that we're going to explore all the different things that project managers do terribly wrong. I think that would be unfair, and it wouldn't really give suitable recognition to the position that the project manager is placed in at the centre of the project and the extensive duties that it owes. The key point that we really wanted to flush out and carries over from the cases that we've seen is it cannot be left to the project manager simply to manage and coordinate all of the work on a given project, especially with the projects that are of such a scale that we see today. It's for all parties to invest in that collaboration and that coordination. Obviously, the project manager has that key central function to perform and should be held to account for doing so. But to close, it's argued that it would be ill-advised to allow the project managers to proceed on their own. Well, that brings to an end the third and final webinar in this series. We hope you found the webinar useful. We hope you found it interesting. If you've got any questions about today's talk or about the topics that we've been discussing today or any other issues arising out of your construction projects, please do not hesitate to get in touch with us. And that concludes our webinar for today. Thank you very much indeed for listening.
Thank you.